and thanks to the Samuel Griffith Society for organising this event tonight. I wanted to talk to you tonight about what I call my American Odyssey. As Xavier just pointed out, during 2018, I spent several months in the United States, based at the Federal Judicial Center in Washington, D.C. It is known affectionately by the judges in America as the FJC. By 2018, I had been a judge of this court for more than 10 years. So I accessed my long service leave, and my wife and I traveled to Washington. We took a flat in Georgetown, and each day I would commute on the train over to Union Station. Many of you will be familiar with Union Station. The FJC is right next door to Union Station. I've always taken a keen interest in the United States and in their systems of government. As you will all be aware, the transcripts of the Australian constitutional conventions of the 1890s are full of references to the Constitution of the United States. This is not surprising. The prevailing circumstances in Australia in the 1890s were similar in a number of key respects to the situation in America in the late 18th century. Former British colonies, situated on a large continent, a long way from Europe, and hoping to prosper through an increase in trade, seeking federation and seeking independence from colonial rule. All of those factors existed in the United States, and indeed they existed here in Australia. In Australia, of course, we wanted to remain firmly within the British Empire, and so we established a constitutional monarchy. We rejected the republican system of government. We retained the British system of responsible government, but we still produced a constitution with a similar framework to the American document, and we adopted many aspects of the American federal system. To some extent, we are betwixt and between, not quite the British system, not quite the American system. I prefer to think of Australia as unique in that respect, drawing on the strengths of both systems. We went so far as to copy the American numbering system, Articles 1, 2, and 3, of the United States Constitution established the three branches of government: legislative, executive, and judiciary. Chapters 1, 2, and 3 of our Constitution do the same. We may be betwixt and between, but I do think that the strength and the stability of our Australian arrangements cannot be denied. For 120 years, the Australian Commonwealth has steered a steady course. But I have taken the view, so far as our constitutional arrangements are concerned, that it is never a good idea to become complacent. It is always a good idea to see how things are done in another country, especially a country that shares our values. It is also always a good idea, in my view, to have a look at what's happening in the United States. Samuel Griffiths, Edmund Barton, Alfred Deakin, Andrew Inglis Clark, all of these men looked to America when writing our Constitution. That is a good enough reason to again look to the United States to see how they are doing things across the Pacific. Of particular interest to me is the following. In the American constitutional landscape, there are two noteworthy occasions when the Congress, the first branch, interacts directly with the federal courts, the third branch. I was lucky enough to witness those events firsthand in 2018. The first example relates to money. The Congress is responsible for appropriating money from the Treasury. So the judiciary goes to the Congress each year to ask for money. The second example relates to the role of the United States Senate in the appointment of federal judges. And I must say, for sheer drama, nothing on Broadway comes close to a confirmation hearing for a federal judge in the United States. In relation to the money issue, the relationship between the Congress and the American federal judges is fascinating when looked at through Australian eyes. This is because our federal judiciary does not interact in any formal sense with our parliament. Prior to 1920 in the United States, the budget for the federal courts was set by the Department of Justice, that is the executive branch of government. The money was still appropriated from the Treasury by the Congress. A man named William Howard Taft had been the President of the United States for one term, and I'm sure you've all heard of him, from 1909. In 1921, he became the Chief Justice of the United States, and you'll be well aware that he is the first and only person to hold both of those offices. Taft used his political acumen, his political friends in the Congress, and his political friends in the White House, and he set about on a path of reform once he became the Chief Justice. He got money from the Congress for the new Supreme Court building in Washington, D.C. If any of you have ever had the opportunity to visit that building, you will agree with how impressive it really is. This was important because prior to the construction of the current building of the Supreme Court in DC, the Supreme Court had sat in the Capitol building, literally inside the legislative branch. The separation of powers obviously is fundamental to the United States Constitution. And I've always taken the view that the separation of powers must not only be done, but it must be seen to be done, much like justice in that respect. So the Supreme Court needed its own building, and Taft got the funding for it. Mind you, it took a while for the building to be constructed, and they didn't move in until 1935. But Taft's experience as president taught him that the judiciary needed to be communicating directly with the Congress, especially on budget issues. Taft knew that what was needed was a permanent, formal line of communication from the judges to the Congress. The Judicial Conference of the United States was established in 1922. The Chief Justice presides over that conference, and all of the federal judges are members. The conference is the national policy-making body for federal judges in the United States. The Judicial Conference is the body which deals directly with the Congress. The Judicial Conference, of course, is contained wholly within the third branch of government, wholly within the judiciary, and it deals with the first branch of government, the Congress. Each year at budget time, a federal judge, a senior federal judge, appears before the Congress and sets out the budget request on behalf of the third branch. In 2018, I was present on Capitol Hill at the House of Representatives Appropriations Committee, and I observed this process firsthand. The senior federal judge involved was a man named Judge John Lungstrom from Kansas City, Missouri. He'd been a judge for about 20 years. He'd been a member of the Budget Committee of the Judicial Conference for many years. He appeared with a gentleman from the Administrative Office of the United States Courts, also a body completely within the third branch. They put forward the budget request. The Appropriations Committee chair was a Republican from Georgia named Tom Graves, and the deputy was a Democrat from Chicago, Michael Quigley. Interestingly, after the most recent midterm elections, you'll be aware that the Democrats won control of the House of Representatives. Those two gentlemen, Graves and Quigley, remained on that committee, and they swapped positions. Quigley now chairs the committee. What I did see in the Appropriations Committee relating to the federal courts in the United States was a good deal of bipartisanship. Neither party wants to be seen as a party that is against making sure that the courts are well funded. They are all keen for bipartisanship. They are keen to make sure the budget is what it should be. The members of Congress, as you will understand, take a keen interest in what is happening in their own district. Obviously, they are all very keen to ensure that there's adequate resources for their own region. Importantly, though, and this is what I think the members of the Samuel Griffith Society will find interesting, the legislature is at the heart of the process. By way of interest, the budget for the federal courts in the United States in recent years is in the vicinity of $7 billion. The other house of Congress, the United States Senate, also plays a crucial role so far as the courts are concerned, this time in relation to appointments to those courts. Many of you will be aware, because over the years you will have watched the great drama surrounding potential nominees or potential judges such as Robert Bork, Merrick Garland, And of course, recently, Brett Kavanaugh, who of course was eventually confirmed. Appointments, of course, are by the President, but they must be confirmed by the Senate. And what is required is the advice and consent of the Senate under Article 2 of the US Constitution. At the Society's conference in Melbourne in August last year, some of you may well have been there, Dr. Murray Cranston delivered a very informative address about the appointment process. Dr. Cranston made a particular mention of Judge Andrew Oldham and his Honour's appointment to the Fifth Circuit Court of Appeals. In a remarkable coincidence, I was present in Washington, DC at the confirmation hearing of Judge Oldham. This was conducted, of course, by the Senate Judiciary Committee. I spent many days with the United States Senate Judiciary Committee. At that time, the chair of the committee was Senator Chuck Grassley. He's a Republican from Iowa. In Senator Grassley's office, he has a model of a John Deere tractor on his desk. He was delighted to hear that I had driven a John Deere in my youth. He was first elected to the Senate in 1980 when Ronald Reagan became the president, and he was very proud to tell me that he is a pig farmer from Iowa. And here he is, the chair of the Senate Judiciary Committee. At least he was until Lindsey Graham took over more recently. One of the things about Chuck Grassley, it occurred to me that he was the most constitutionally astute pig farmer I had ever met. Senator Grassley introduced me to the members of the committee. Prior to the confirmation hearings, we had a very pleasant cup of coffee in the anteroom to the hearing room. And many of the names you'll recognise, these various senators from around the United States, Senator Lay and Senator Feinstein, Senator Lindsey Graham, Ted Cruz, Orrin Hatch, Mike Lee, Cory Booker. I'd like to set the scene for you. The hearing takes place in a wood-panelled room situated in a building on Capitol Hill in Washington. The senators sit on an elevated bench in a semicircle. The nominee sits at a table at floor level. The room is full of people. The nominee, that is the potential judge, the nominee's family are present. His parents are present. His in-laws are present. Friends and colleagues were present. His political supporters from his home state were present, complete with their 10-gallon hats, the Fifth Circuit taking in much of Texas. It was a remarkable scene to watch a man's life, career, plans, dreams and ambitions opened like a book for the whole country to see. In Australia, you will all be aware, our friends and family show up to play the same kind of supportive role, but that is only once the appointment has been made. It is an altogether different dynamic in the United States. The friendly cup of coffee that I had enjoyed with the senators in the anteroom prior to the hearing did not carry over into the hearing itself. The senators are entitled to, and they do in fact, question the nominee. At Judge Oldham's confirmation hearing, he was grilled at some length in relation to all kinds of issues, including his view on abortion, his view on immigration, his view on the Second Amendment, that is the right to bear arms. He was also asked for his view on the Environmental Protection Agency and his view on sanctuary cities. There is one question which is asked very often at the confirmation hearings. The question is, do you consider that the decision of the Supreme Court in Brown against the Board of Education was correctly decided? Brown against the Board of Education is, of course, the famous racial segregation case decided by the Supreme Court in 1954. The questions that are fired at the nominee are nothing short of incendiary. The questions relate to the most divisive political issues imaginable. It makes for a gut-wrenching drama. There is a frank openness about the process, but it is like a blunt instrument. The nominees are visibly drained by the process. I have to confess, I had a good deal of sympathy for the nominees. Our process in Australia is altogether more gentle. The legislature in the United States stands at the center of the constitutional landscape. The core principle underlying this approach is that everything is laid bare before the American public. The Congress scrutinizes everything. The Congress directs everything. This includes the matters which directly impact on the federal courts. After I completed my research in Washington, D.C., my odyssey continued. The FJC organised for me to visit many of the federal courts in the northeast of the United States. You will appreciate that it is one thing to be in Washington, D.C. and to be told how effective their governmental processes are, and to learn all about how the federal courts obtain funding and resources. It's another thing altogether to visit the judges in the various regions to see whether, in fact, the processes that they have in place in Washington are filtering through in terms of resourcing for the courts in the various regions, circuits, and states. When I arrived at the federal court in New York, I met with Judge Denny Chin. Judge Chin is famous because he sentenced Bernie Madoff to 150 years in prison for the great Ponzi scheme debacle. Judge Denny Chin had a very interesting story. He was born in Hong Kong, but was taken by his parents to the United States at the age of 2. When I arrived at the court in New York, Judge Chin informed me that I would be addressing 800 high school students that day from Staten Island. I was happy to do that. They were there to discuss the separation of powers and the United States Constitution, but it turned out, once they had an Australian judge in the building, they wanted to hear about our Australian courts and about our Constitution. These high school students were all very well versed in relation to their own Constitution and their 3 branches of government, and the separation of powers and the reason for the separation of powers. I was lucky enough to have lunch with these high school students in the court cafeteria after the speech. I must say, they were a wonderful group of young people. Judge Chin had spoken to them about the American system. I spoke about the Australian system. And I must say, I did wonder whether many of our Australian high school students would be so interested in constitutional arrangements. After visiting the Second Circuit there in New York, I travelled to Boston, the First Circuit, Rhode Island, Vermont, Maine. Apart from New York, I was told that I was the first Australian judge to visit those other circuits. That was particularly surprising for me in relation to Boston. There is a very large, new and impressive federal court building right on Boston Harbour called the Moakley, named after one of their congressmen who obtained the funding for the building. Once it was known around the building that there was an Australian judge invited for a meeting and a sandwich lunch. The judges came in from everywhere. It was most enjoyable. They were very hospitable. I was made very welcome in each state, and without exception, the judges wanted to hear all about Australia and about our federal system. Many had already visited Australia, and everyone who hadn't visited expressed a desire to visit one day. Some, though, I have to tell you, were very worried that they were likely to be eaten by a shark or a crocodile or bitten by a spider or a snake. They seem to have this view in their minds that there are crocodiles roaming George Street in Sydney. Apart from that, they were very keen to visit. They were very pleased to hear about how our own fathers of federation had turned to America in the drafting of our own Constitution. As is their nature, the American judges, as I say, were welcoming, they were hospitable and kind, they were happy with their lot, and they were conscious of the important role that they play in the constitutional arrangements for the United States. It was my privilege to spend time in the United States and observe their constitutional government in action. As I said earlier, I was particularly interested in the role played by their Congress and how everything in the United States in constitutional terms, including interaction between the courts and the first branch of government, everything gets drawn back to the Congress, which really means it's laid bare before the public. I hope that you've enjoyed some of my reflections about my American Odyssey. I'm more than happy to take questions. I deliberately planned tonight to not make this speech too long, hoping that there'll be plenty of questions in relation to the way the Americans do things. So I'm very keen to hear what people have to say. Xavier, go ahead. Thank you.